get a break somewhere between 9:40 and 9:45 so that you have enough coffee to listen to Mike Schmitt's longer speech at the end of this. By way of background, Mike and I worked together at the Naval War College, and you can fault him for training me when I was a student in command and staff years ago. So I'm able to make fun of him at will, and he enjoys it. Okay, we've had our first casualty of the conference. One of our speakers got caught in a storm in the Midwest, so he won't be joining us. So as always, we're flexible in the Navy, and we've come up with a new plan. So the plan that we'll go over first is we're going to have Matt go first, and he's going to talk to us, and then Mike's going to chime in, because Mike likes to chime in, and he'll speak for about 10 minutes about what Sean Watts was going to talk about. We'll take your coffee break, because you'll need it by then. Then we'll pick up with Professor Derek Jinks, our Stockton chair, and then we'll end up with Mike again, because he likes the last word.
Will this be going on a long time, Stacy?
The questions, we'll do our comedy routine tonight at the club. The question and answer period will be at the very end, and Mike Karsten would like for everybody to limit their questions and comments to one question per person and one comment per person for those of you that are still awake enough to ask questions and make comments. Then I'll have all the speakers chime in and talk about it. Okay, what are we going to talk about? Actually, my panel, keeping me ever flexible, has changed the name of the panel from what it was originally envisioned to be. And I think it's now called the Use of Force in Cyberspace. Since they don't have those screens on, I'll have to look at my own notes. What we intend to do is give a brief factual overview. We'll flash that up on the screen. And I won't go into details about the facts that the speakers will use as a basis for the discussion. I'll let them do that in their legal analysis. And then each of them have chosen a different aspect of the analysis of the use of force in cyberspace. And they'll talk about the facts of the Estonia and Georgia attacks when looking at the problem. Two comments by way of background. I think any legal analysis in the use of force in cyberspace is somewhat hamstrung by the fact that a lot of the information and factual information is classified, and we can't really talk about real facts. We can talk about the law, we can talk about the use of force, and we can talk about the facts that governments have chosen to release or not with regard to a particular incident. So I think we are somewhat challenged in a full discussion of it because much of the information is classified and much of the information is compartmented, even if it is classified. So by way of background, we're going to talk about the Estonia and the Georgia attacks in 2007, 2008, respectively, but those aren't the only cyber attacks that have been discussed in an unclassified fora. As you know, the United States has suffered numerous cyber attacks, including Central Command. Their entire system was hacked into, and much of the information about the two ongoing wars was made available. Also, Brazil suffered from a huge cyber attack several years ago, and that's been discussed in unclassified fora as well. So although the speakers are going to use Estonia and Georgia as a basis for their comments, by no stretch of imagination are those the only instances that we have that have been used and discussed in the form of cyber attacks. Next slide. Background on Estonia. Everybody take a look at that slide. When you talk volume, you see that some sites that typically received 1,000 visits a day were flooded with 2,000 visits per second. And the scope of this attack was varied, and it's been discussed in a lot of different papers, academic papers, and in the media as a wide-ranging attack. Some characterize it as a cyber attack, others just characterize it as a cyber riot, and one person even made an analogy with sort of the web defacement that occurred during the EP3 incident with China. Pete and I were talking about that because we're geeks and talk about stuff like this over coffee in the morning. And quite frankly, until I'd done the research, I didn't even realize there were, cyber defacements during the EP3 incident. We were so overwhelmed with the ridiculousness of their argument, the Chinese argument that a fighter jet had been overtaken by the low, slow flyer, that we were sort of missed the cyber aspect of that whole web defacement. But anyway, during these cyber attacks in Estonia, there were a range of opinions about whether or not it was attributable to the government of Russia, and of course Russia denied it. And eventually NATO and, next slide, NATO and the EC came out and said that they couldn't actually attribute it to the government. So there's a debate as to whether or not it was state-sponsored to begin with, and in fact only one person ultimately was prosecuted for that, and he was an ethnic Estonian Russian who was actually fined a little in excess of $1,000 US for that incident. Next slide. Important point on the last slide was that the Russian authorities continued to sort of hamstring the investigation, and that's why other folks were never brought for prosecution. The opinions from cyber experts, and these are not the lawyers, these are the techies, they say it may have involved cooperation from a state, that hackers may have acted under some sort of recommendations from somebody in the government, but some say it was more like a riot, as I alluded earlier, than any sort of cyber attack. So various aspects of this issue will be discussed in more factual detail through the speaker's legal analysis. What was the reaction? Next slide. A lot of militaries got nervous about it and reevaluated their network security. NATO held a meeting on cybersecurity and issued a joint communique. The conference in Estonia that I believe a couple of the speakers attended last week was sort of an outgrowth of that in terms of the legal analysis. And then it triggered a huge discussion and analysis on the use of force in the cyber environment. For those of you that have been monitoring the papers recently, there's been lots of testimony. There was a 60 minutes thing on cyber warfare talking about the risk to the U.S. government and the number of terabytes of information that have been stolen, the risk to electric security grids, and this issue is really at the forefront both of techies and the legal community, but again, hamstrung by the fact that we can't really discuss it in any factual detail in an unclassified setting. Next slide, let's move on quickly to the Georgia cyber attacks. That happened during the 2008 war. There was a series of cyber attacks, and numerous South Ossetian, Russian, Georgian, and Azerbaijani organizations happened 3 days before the invasion, and it impacted websites, news agencies, and radios were hacked. The website, in one instance, kept the header and the logo, but the content was altered. The other cyber attack caused the Parliament of Georgia and Georgian military foreign affairs websites to be replaced by images comparing the Georgian president to Adolf Hitler. So again, lots of discussion about whether or not this was state-sponsored or attributable to a state or a government, and what response was appropriate in terms of use of force. There was denial of service attacks to Georgian websites, and then Russian hackers allegedly disabled the servers of the Azerbaijani Day news agency. Again, the Russian government denied any involvement and said the attacks may be attributable to individual hackers or to criminal gangs. So those are basic factual overviews of some of the technical issues, political issues associated with this that our speakers will talk about in more detail. Okay, it's now my privilege to introduce our speakers, and we're going to go a little bit out of order from what your information says. First, we're pleased to have Professor Matthew Waxman, goes by Matt. He's an associate professor of law at Columbia Law School, where he specializes in international law and national security law. He's also an adjunct senior fellow for law and foreign policy at the Council on Foreign Relations and a member of the Hoover Institution Task Force on National Security and Law. He previously served at the U.S. State Department as a principal deputy director of policy planning. He has prior government appointments, including Deputy Assistant Secretary of Defense for Detainee Affairs, Director for Contingency Planning and International Justice at the National Security Council, Special Assistant to National Security Advisor Condoleezza Rice. Please welcome Professor Waxman, and next slide, please, is the list of things that they'll be talking about. Okay, we are technologically challenged and now have suffered a cyber attack of our last slide. Professor Matt Waxman will talk about the prohibition or the threat of use of force, conducting an analysis under the UN Charter Article 2.4. Matt?
Great. Well, thank you very much, and it's great to be back here in Newport. I'm excited to be on this panel. As Stacy said, I'm going to begin the discussion of cyber attacks, cyber warfare, and the UN Charter focusing on Article 2.4 and its prohibition on force or the threats of force. I'm going to change the facts we were given just a little bit for simplicity. So suppose that Russia is engaged in an intense diplomatic conflict with a much smaller, weaker former Soviet republic that we'll call hypothetically Waxmania. And this hypothetical country, Waxmania, is heavily dependent for its energy needs on natural gas imported from Russia. And suppose further that the Russian leadership, in an effort to escalate the crisis, considers three options. One, it could launch airstrikes against Waxmania's natural gas refining and distribution infrastructure, just a military attack, a bombardment. Second, it could turn off the spigot of natural gas and deprive Waxmania of this critical energy import. Or third, it could electronically penetrate the computer systems that control Waxmania's natural gas facilities, scramble the data, and ensure that distribution system is crippled. Which of these actions constitutes a use of force subject to the UN Charter's prohibitions and self-defense provisions? I posed this hypothetical set of options for two reasons. First, as an exercise in legal line drawing, I think the deployment of new technologies raise important questions about permissible versus impermissible modes of interstate diplomacy and conflict. Except in self-defense and when authorized by the UN Security Council, armed attacks are generally illegal. Mike Schmitt will speak further about that. But on the other hand, most economic and diplomatic measures, even if they exact a tremendous cost or have coercive effects, may not be barred by the UN Charter. Where along this spectrum do cyber attacks or different types of cyber attacks fall? And for my purposes, I'm defining cyber attacks as efforts to alter, disrupt, degrade, or destroy computer systems or networks or the informations or programs on them. The second reason, besides an exercise in legal line drawing, that I pose this hypothetical example as I do, is to illustrate that any legal line drawing produces winners and losers. And I'm confining my analysis here to states, but it produces winners and losers because states have different strategic capabilities and different vulnerabilities to those capabilities. Not all states, for example, have the financial and trade or economic muscle to coerce other states economically, and states have varying strength to withstand certain types of pressure. And I think the same is true for cyber attacks. The rules, therefore, that affect the cost of cyber attacks are going to have disparate strategic consequences across states. In short, legal line drawing with respect to force and modes of conflict has distributive effects on power, and it's therefore likely to be shaped by the distribution of power in the international system. To make these forward-looking points about international law and what are really cutting-edge or future technologies, I look backwards in time to international legal disputes and scholarly debates of the Cold War. In fact, a central theme of my talk here today is that the fundamental issues involved in regulating cyber attacks as a mode of force are neither new nor unique to cyber technology. Modes and technologies of conflict change, and the law adjusts with varying degrees of success in dealing with those changes. Cyber warfare capabilities and vulnerabilities will again strain the UN Charter, but I think the lessons of history help show us how. So to back up, modern legal regulation of resort to force generally begins with the UN Charter and specifically Article 2.4. That provision directs that, quote, all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state or in any other matter inconsistent with the purposes of the United Nations. Article 51, which Mike will talk about, then provides that, quote, nothing in the present charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs. The dominant view in the United States and among its allies has long been that the Article 2.4 prohibition on force or threats of force, as well as the complementary right of self-defense under Article 51, apply to military attacks or armed violence. Personally, I agree with this view that the plain meaning of the Charter text, as well as other structural aspects of the UN Charter, tend to support that view, though there are counter views that I'll talk about in a moment. Under the strictest version of this approach, only the first scenario that I described above, an airstrike against Waxmania's energy facilities, clearly could violate Article 2.4. And perhaps also give rise to an Article 51 right of self-defense. The others may or may not be illegal under international law in other ways, but only the first, the airstrike, involved the application of military force. Another view of Article 2.4 is to look not just at the instrument, but at its purpose and general effect. That Article 2.4's prohibition on the use or threat of force is really about prohibiting coercion. Armed force, of course, is one instrument of coercion and the easiest to identify, but this interpretation of Article 2.4 stresses its purpose over text, and at various times some states, usually those of the developing world or during the Cold War, what was known as the Third World, have pushed this notion that force includes other forms of pressure, including political and economic coercion, especially that's threatening to a state's independence. And I think under this approach, any or all three of the scenarios that I outlined above, the airstrikes, turning off the gas spigot, or a cyber attack could conceivably constitute prohibited force under the UN Charter. Each is intended to exert coercive force, to compel behavior by exacting or threatening costs. A problem, though, with this approach has always been the difficulty of distinguishing unlawful coercion from lawful pressure. And after all, coercion is a part of everyday diplomacy and statecraft. For argument's sake, let me just throw out a third possible approach towards interpreting Article 2.4, which might focus on the violation and defense of rights, specifically states' rights of sovereign dominion. Such an approach might tie the concept of force to, let's say, improper interference with the rights of other states, including efforts to subvert their economic and political system. Now, to whatever extent Article 2.4's meaning was settled and stable by the end of the Cold War in favor generally of the narrow interpretation focused on military force, cyber warfare, cyber attacks pose some challenges. Offensive cyber capabilities, such as taking down public or private computer networks or systems that rely on them, bear some similarities to the use of kinetic military force, but also to economic coercion, and also bear some resemblance to political or economic subversion. Yet they also, cyber attacks have some unique characteristics and are themselves, I think, evolving and in some unpredictable ways. As far as I know, the United States government hasn't yet articulated a general position on cyber attacks and Article 2.4. However, there seems to be considerable momentum both within the government and within the American Academy that cyber attacks ought to fall within Article 2.4's prohibitions on force insofar as those terms could be interpreted to cover attacks with features and effects closely resembling those brought about by conventional military attacks or kinetic force. And I think we see this, as I say, in a number of government statements that I'll be happy to elaborate in question and answer if necessary. And I think the United States probably prefers this sort of effects-based interpretation of force when it comes to cyber attack, not only for what it includes, what it therefore prohibits, and what it could therefore trigger in terms of Article 51 self-defense rights, but also for what it excludes. And that includes computer-based espionage or intelligence collection. For example, the United States would probably argue would not constitute prohibited force because it doesn't produce direct or even indirect destructive consequences analogous to a military attack. From a U.S. standpoint, some legal guidance on this is important, both to plan and guide offensive and defensive military or cyber actions, as well as to signal U.S. intentions, and these emerging interpretations emphasizing the effects of cyber attacks are, in my mind, quite reasonable. But looking more broadly at the international system, taking a step back, how likely is it that this sort of effects-based interpretation is likely to take hold? This is where I think it's useful to take a step back in time and look at some of the similar debates about Article 2.4 and its meaning during the Cold War. So about midway through the Cold War in 1970, the late Thomas Frank famously lamented the quote, death of Article 2.4 in the pages of the American Journal of International Law. He believed that the rapid changes in the way conflict was waged had made Article 2.4's prohibitions on force obsolete. And let me quote here for a moment. Small-scale wars and subversion and counter-subversion waged through local proxies became a common mode of superpower conflict rather than direct conventional military action. Superpowers routinely supported insurgencies, rebel movements, and coups against states supporting the other power with various forms of assistance, including arms. At the same time, the rapid and devastating nature of nuclear attacks and the development of deterrence doctrines meant that major powers were locked in a permanent state of threatened force, end quote. In both respects, Frank's argument was that the technology, broadly speaking, and strategy of conflict had moved in directions for which the UN Charter's basic prohibitions and regulatory content was ill-equipped. In retrospect, I think Frank was half right. While the UN Charter could never really effectively prohibit warfare completely without strong supranational institutions, powerful and independent enough to enforce the Charter, Article 2.4's prohibitions could make aggression less likely or influence the way in which warfare or aggression was conducted by raising the costs of certain types of actions. I think it's Article 2.4's basic prohibitions had some strength and resilience despite this technological flux because powerful states shared a collective interest in the Charter's vitality, especially when any conventional conflict had the potential to escalate dramatically. But Frank was right to look beyond whether states merely used force at all to the way in which they used it in order to assess Article 2.4's strength and continuing value, and especially whether it had the ability to help impose costs on purported violators and could keep pace with changing warfare. Indeed, the costs that Article 2.4 imposed on conventional military attacks across borders may have even had some, what economists might call, substitution effects, pushing actors in the international system towards other modes of conflict that were less diplomatically costly. I think the questions for our purposes, for cyber warfare, then follow, can Article 2.4's contours and shape adjust to cyber capabilities in ways that also differentiate illicit conduct from legal? Can those changes help impose costs for non-compliance? And in doing so, can they command and respect wide support and authority among powerful actors in the international system? I think a lesson of Cold War history with regard to Article 2.4 is not only that reaching broad international consensus on Article 2.4's meaning can be slow and difficult, especially as technologies develop, but that some technologies or modes of conflict are especially challenging to regulate because their features, the features of those technologies or modes of conflict match poorly with the general enforcement mechanisms of international law regulating force. And I like quoting Professor Michael Reisman here, quote, "International law is still largely a decentralized process in which much lawmaking, particularly for the most innovative matters, is initiated by unilateral claim, whether explicit or behavioral. Claims to change inherited security arrangements ignite a process of counterclaims, responses, replies, and rejoinders until stable expectations of right behavior emerge." Now, given that notion of the way in which the Charter's prohibitions might evolve and be enforced, one reason I think why cyber attacks will be especially difficult to regulate is that the factual bases for asserting a violation of 2.4 will be subject to great uncertainty, debate, and verifiably. And I think that point came across very well in Stacy's introductory remarks. Those who study the problem of cyber attacks are usually quick to point out the problems of identification and attribution. That is, that it's not always possible to discern quickly, precisely, or accurately who launched or directed a cyber attack. The nature of electronic informational infrastructure and forensics is that it may be very difficult technically to link an attack to the responsible party, especially once State B takes defensive and perhaps offensive countermeasures against State A. All in cyberspace, it may be especially difficult, I think, to untangle the important strands of fact, let alone associate them with some specific effects and then assign them clear legal significance. Again, though, I want to argue that this is not an entirely new problem for Article 2.4. The issue of attribution arose in the Cold War context as well. And again, let me quote Frank here and suggest, as I quote Thomas Frank, that I think one could very easily substitute the term cyber attacks directly into this quote from 1970. Quote, "While it may not always be possible, even in classical combat, to determine which army had started marching first, the scale, formations, and strategy of conventional warfare did make the identification of aggression relatively easy. It stretched everyone's credulity to be told that Poland had attacked Germany or South Korea the North, when the armies of these self-proclaimed victims were, right at the very beginning, to be seen as overrunning their opponents. With the hit-and-run tactics of wars of national liberation, on the other hand, it is often difficult even to establish convincingly from a pattern of isolated, gradually cumulative events when or where the first round began, let alone at whose instigation or who won it." End quote. In other words, once conflict was waged through proxies in the Cold War, it was difficult to develop an international consensus about the relevant facts in particular crises, and then assign or apportion jus ad bellum liability and justification to that set of facts. Now, this legal factual murkiness helps explain, I think, why Article 2.4 seemed to Frank and others so impotent in addressing that form of conflict, but also why that mode of conflict offered an appealing option to the Cold War antagonists. Like these prior proxy wars, I think cyber conflict is likely to feature disputed facts about what exactly occurred, including who committed the electronic intrusion or disruption, and on whose behalf they were doing it. And like proxy wars, this probable haziness may make cyber attacks an appealing option. I think we've already seen that in some of the in some of the examples that Stacy highlighted. Even if forensic processes can trace a cyber attack to its source, it may be difficult to publicize that information in a timely and convincing way, especially when states or private entities are likely to have a very strong incentive not to want to discuss the technical details of informational security breaches or reveal their own capabilities and intrusions. So consider the case of Estonia from 2007 that was referred to earlier, in which it took months to compile still murky information about the source of the attacks, and many key facts, including the ultimate responsibility for directing or encouraging those attacks, I think remain subject to some dispute. Evidence of Russian government involvement was mostly circumstantial, compromised computers existed across 4 or 5 different continents, and Russian officials denied involvement. I think all of this looks a lot, in my mind, like proxy wars in the third world of the past. And like proxy wars of the Cold War, I think cyber warfare may lack clearly discernible starting points and readily observable or provable actions and counteractions. This doesn't mean, I don't want to argue here that legal line drawing is therefore impossible. It does mean, though, that the processes that Professor Reisman describes of claims and counterclaims towards eventually, I think, a stable outcome, or the accretion of interpretive practice that commands broad international consensus, I think is likely to be a slow and uncertain one when it comes to Article 2.4 and cyber attacks. Now, besides the relationship between law and changing technologies of conflict, I think the Cold War debates about Article 2.4 illustrate some important principles about the relationship between law and power. Competing interpretations of Article 2.4 have always reflected distributions of power in the international system. And I think as a corollary, efforts to revise the legal rules, those legal rules, to reinterpret them, may have reallocative effects on power by raising or lowering the costs of using certain resources or capabilities that are themselves inequitably distributed. As noted above, a major Cold War debate about Article 2.4, one pitting groupings of the world's states as well as scholars, concerned the substantive scope of Article 2.4. Did Article 2.4 ban military violence? Is that what it was about? Or, on the other hand, did it ban coercion, including economic coercion? The position of the Southern Hemisphere, or the Third World, that it prohibited coercion, I think never really gained much traction as a matter of authoritative practice. The more restrictive interpretation backed by the United States and its allies, those with more power, generally won out. And from the perspective of the United States, this generally seemed like a pretty good deal during the Cold War, right? The costs placed on, by international law on states resorting first to military force or conventional armed force in a crisis were high, thereby generally helping to preserve territorial stability and prevent escalation. In the meantime, the United States, which had a lot of economic power, could grow its defenses, grow its economy, expand its influence, all at that time relatively free under the UN Charter, at least, to sort of to throw its economic weight around against weaker states. Now, this, like I say, all seemed like a pretty good arrangement, I think, maybe until around the Arab states launched an oil embargo in 1973, and suddenly that general deal might not have seemed quite as good as it did originally, but still pretty good. Where one stands, I think, on Article 2.4 has historically depended on where one sits in terms of the distribution of resources and power, including whether one is a satisfied or unsatisfied state with regard to the status quo. Debate similar to that over the definition of force and armed attack in the UN Charter also therefore played out in the UN General Assembly over the definition of aggression, with the United States and its Western allies generally pushing a narrow definition focused on military attacks, and developing states pushing a more expansive definition to include coercion, economic pressure, and subversion. Moreover, I think generally those with more power have a greater ability to impose, defend, and promote through state practice their preferred interpretation. With that relationship between law and power in mind, let me just suggest that a reason that the United States, I think, has an interest in tightly regulating cyber attacks, offensive cyber attacks, but why it will be difficult, I think, to do so through the UN Charter and through Article 2.4 is because the distribution of emerging cyber capabilities and vulnerabilities determined not just in the ability to defend against a cyber attack, but to tolerate the effects of disruption of systems that depend on information running in cyberspace, that distribution of capabilities and vulnerabilities may not correspond to status quo distribution of power built on traditional measures of military power and economic power. I think it's natural that the United States might prefer an interpretation of Article 2.4 that allows it to classify offensive cyber attacks as prohibited force, but that does not otherwise, I think, alter the general lines of prohibition drawn during the Cold War in ways that exclude economic coercion and other modes of subversion, because some U.S. strengths are built on global information interconnectedness and infrastructure that is itself global, mostly private, and rapidly morphing. And I think the U.S. vulnerabilities are therefore inextricably linked to new and emerging vulnerabilities. Meanwhile, some other states that are developing offensive cyber warfare capabilities I see as non-status quo powers or aspiring regional powers. Offensive cyber capabilities for them, I think, may offer an appealing potential to shift or upset existing or past balances of power because some states are more vulnerable than others to cyber attack, and cyber attacks could have disproportionate effects on different types of states. So in that light, I see U.S. legal interpretations as they've begun to sort of trickle out, or declaratory postures with regard to cyber attacks that define prohibited force in ways that include hostile means for which traditional narrow interpretations of Article 2.4 may have been ill-suited. I think we can see those as part of a broader effort to sustain a legal order in which anticipated U.S. military and economic moves and counter-moves against potential adversaries fit quite comfortably. A legal order that preserves U.S. comparative advantages. In extending the foundational UN Charter prohibition on force to cyber attacks, I think by emphasizing their comparable effects to conventional military attacks, these kinds of interpretations help deny that cyber capability to others by raising the costs of its use. And at the same time, by casting that prohibition in terms that, as Mike will probably talk about, help justify military force in self-defensive response to cyber attacks, this interpretation reduces the costs on the United States of using or threatening its comparative military edge. Now, let me just conclude in that regard by saying that any drawing or redrawing of legal lines on a map of inequitably distributed power and vulnerabilities, to repeat from before, create some winners and losers. However, it will make it, I think, also difficult to reach agreement on legal boundaries, especially whether it's through new conventions or interpretation of the UN Charter. In thinking, therefore, about a legal interpretation or reform of interpretation of Article 2.4, success, I think, therefore, in the long term, depends on the ability of proponents of change not only to articulate, but to defend those legal lines using combinations of traditional and new forms of power for deterrence, self-defense, enforcement, and influence. That is, I think, the strength of any new legal regime when it comes to cyberspace will depend on the distribution of power, which itself is in some considerable flux. Again, just to conclude, cyber attacks pose difficult line drawing problems, but I think we need to avoid missing the strategic forest in thinking about the legal trees. The problem of cyber warfare for regulating force is at the same time novel yet quite familiar. Viewing these issues in the context of Cold War debates reveals that although the technology of conflict, both in terms of capabilities and probable vulnerabilities, is changing in some radical ways, the notion that destructive potential is deliverable with non-military means is a repeating one. Proposals for reform should consider the features of new modes of conflict that make legal regulation especially difficult, and the way legal interpretations inevitably create strategic winners and losers. In short, interpretations prohibitive of cyber attacks can help check new forms of destructive power, but only if those legal moves are themselves backed up with effective mixes of power.
Thank you very much, Matt, for a very interesting and provocative speech which kept the vast majority of folks awake without the coffee break. It's now my pleasure to do two things. One, compliment Matt on his talk and providing us a new quote about avoiding losing the strategic forest for legal trees. That has got to be my personal favorite so far of the last 2 days. And secondly, it's my privilege to introduce Professor Mike Schmitt, and he's coughing that I would even say privilege. Mike is a retired Air Force officer who's had a very robust legal career since he retired from the Air Force. He currently is the chair of the Public International Law at Durham University Law School in the United Kingdom, was previously the dean of the Marshall Center for Security Studies in Garmisch, Germany, and he had served there as a professor of international law since 1999. He was also the Stockton chair at the Naval War College in 2007-2008, and was the 2006 visiting scholar at Melbourne University, and has also been a visiting scholar at Yale Law School. Please welcome Mike Schmitt, who will give us a brief 15 minutes or so before your coffee break, filling in for Sean Watts.
First of all, the slide that's shown is not the slide for this presentation, because I'm actually scheduled to speak again after your coffee break, so you'll be truly awake. I found out I was going to do this presentation this morning about an hour ago when we found out that Sean's plane wasn't going to come. So I suspect it will be as unpolished as the play of the English football team in the World Cup. I'm sorry, I live in the UK now, so I have to say such things. My task this morning, or Sean's task this morning, was to talk about Article 51 of the Charter, particularly the law of self-defense. It's useful to place this law in perspective. Let's understand how the system works. You have Article 2.4, which Matt just talked about, which is the prohibition on the use of force. There are two exceptions to that prohibition on the use of force. The first is action that is authorized or mandated by the Security Council under Chapter 7, and then there's Article 51, which is the law of self-defense. Article 51 specifically provides, and the text is very important in the context of cyber, that nothing in the Charter shall impair the inherent right of individual or collective self-defense, and here comes the critical terminology, if an armed attack occurs against a member of the United Nations, and so forth. Now, it's important to understand what this prohibition is. Article 2.4 was about when a country violates international law. I'm conducting a cyber something, a cyber operation, cyber attack, cyber whatever, and the question that Matt addressed is, has my country violated international law? Article 51 is very different. Article 51 is only about what remedies are available to the victim of such an attack. Specifically, can they respond themselves with armed force? It's important to understand that only states enjoy this right of self-defense under Article 51. So if you have a cyber attack against a private company, the private company does not have a right to respond in self-defense. States have a right to respond in self-defense. But of course, the state could respond on behalf of the company that had been attacked in very much the same way that it could respond if its citizens had been attacked. Now, the critical text, as I've mentioned in the prohibition, or in the remedy that's available, is armed attack. Because but for an armed attack, there is no right to respond in self-defense, even if the cyber operation violated Article 2.4's prohibition on the use of force. And this gap is very important. It's been one that's been recognized by the ICJ, most significantly in the Nicaragua, the famous paramilitary activities case, where the court there said that there are measures which do not constitute an armed attack, in other words, Article 51, but may nevertheless involve a use of force, and then went on to distinguish the most grave forms of the use of force from other less grave forms, in other words, of the use of force under Article 2.4, and it excluded the supply of weapons and logistic support to guerrillas as an armed attack, even though it said that they might constitute uses of force. So that gap is very, very important. If you have a violation of Article 2.4, Matt's Article 2.4, but you don't have an armed attack, then your remedies are limited. They're limited to lawful, non-forceful actions, countermeasures, and then recourse to action authorized by the Security Council. And what this means in practical terms is that your state may be the victim of a use of force by another state, but it cannot respond lawfully in kind. It would have to, for example, turn to the Security Council to get it to authorize an in-kind response. Now, once that armed attack has occurred under Article 51, then the Security Council becomes irrelevant, at least with regard to the initial response. So if the action does rise to the level of an armed attack, then you can respond without the Security Council authorization. Now, this begs the question, so what is an armed attack? Matt dealt with what is a use of force. What is an armed attack? The problem is that we're stuck with the text of the Charter. I mean, it does, after all, say armed attacks. If the drafters of the Charter had contemplated massive cyber attacks as they were drafting the Charter, surely they would not have included the term armed, because a massive cyber attack can be much more devastating than a small-scale armed attack. But unfortunately, we are stuck with the law as it's written. Now, with regard to use of force, there's a little bit of interpretive leeway, because the use of force does not include the word armed. The subject was discussed, as Matt mentioned, at the time the Charter was framed. It was not economic coercion and so forth. But there is no such legislative history with regard to the term armed attack. So in my view, this is simply my view, armed attack obviously includes kinetic military force, and if it includes kinetic military force, then it must include non-kinetic actions that have the same consequences or effects of kinetic military force. So in my mind, an armed attack is a cyber operation that causes death or injury to individuals or damage or destruction to property. If a cyber operation doesn't do that, or doesn't at least risk that, then it may qualify as a violation of 2.4, again, what Matt talked about, but it's not an armed attack permitting forceful defensive reaction. Now, you should be very dissatisfied with this. This is a bad result. I mean, this is a bad result because your country suffers a devastating cyber attack that does not rise to this level, and your hands are tied unless you turn to the Security Council, and we're in America, and we know how we feel about turning to the Security Council. So this should make you nervous. And I anticipate that through state practice, the understanding of the Article 51 norm along these lines will change. But that's not the law, at least in my view, right now. Turning to other related topics to self-defense, let's talk briefly about anticipatory self-defense, because states need not sit idly by while other states prepare to attack them. They may respond in the face of an imminent attack. I know this is somewhat controversial. Jorm Dinstein's not here, thank God, so we don't have to talk about interceptive self-defense and so forth. But it has been recognized since at least the time of the Carolyn case, although Carolyn was not a self-defense case, that there is this right to not stand by while the other guy gets ready to attack you, and that's true in the cyber world. Now, in 2002, President Bush issues the National Security Strategy, in which he suggests a reinterpretation of the law of self-defense as necessary in light of current circumstances, those circumstances being terrorism, because terrorists strike without warning and the attack may be catastrophic. I personally don't feel any reinterpretation is necessary at all, because you have to look at the underlying premise of self-defense. And the underlying premise is that states should be entitled to effectively defend themselves before an aggressive blow falls. You should not have to take the first shot, if you will. And in my mind, this has always been the law. So because of the nature of warfare, we've always understood this concept of anticipatory self-defense temporally. How soon is the attack going to fall? I can only respond when it's about to fall. In other words, I'm thinking in temporal terms. That doesn't really work well in this current context. So I think the law today, reasonably interpreted, not a change in the law, but reasonably interpreted, is you have the right to respond when your last window of opportunity to mount an effective defense is about to close. In other words, that may be well before the attack falls or just seconds before the attack falls, but the question you should ask yourself is not how much time. Is it a minute, an hour, a day, or a month? You should be asking yourself, do I have to act now if I am going to mount an effective defense? Because surely international law does not deny states the right to mount effective defenses. Of course, this defense may not be preventive in nature. You don't mount attacks just because your neighbor is developing a cyber capacity that threatens you. The neighbor has to actually threaten you and has to actually intend to conduct the attack before you respond. But once the neighbor forms that intention to attack and has the capability, then at least in my mind, you may respond so long as that's within your last window of opportunity for doing so. As mentioned by the opening speaker, the law of self-defense has really three requirements: necessity, proportionality, and immediacy. In this audience, we certainly don't need to talk much about that. In the cyber context, the key thing with regard to proportionality is to understand that once you have a situation in which there is self-defense, your right to self-defense has matured. Proportionality does not mean you have to respond in kind. So if you are the victim of a cyber attack, you may turn to kinetic means to respond defensively to that cyber attack. You may drop bombs on the country which has conducted the cyber attack against you. Proportionality simply means that you don't use more force than required to defeat the threat or defeat the attack which is underway. And with regard to the principle of necessity, which says that I can only use force if no non-forceful means is available, I think that's relevant in the cyber context as well. For example, if you have robust cyber defenses, then you don't need to respond kinetically. If the enemy can't get through your cyber defenses, just because they've launched an attack doesn't mean you can say, this is great, now let's go get them, let's invade their country. Necessity says you may only resort to force or resort to cyber, rising to the level of an armed attack itself, if non-forceful measures, lesser measures, will not work. It's been noted a couple times this morning, Matt certainly pointed it out, that there is a real problem with regard to cyber. And the problem is that it's difficult to identify who the attacker was. This was a huge problem in Estonia. You know, was the Russian government attacking us? Were they Russian hackers? Were they Russian citizens outside the country, et cetera, et cetera, et cetera? It is, in fact, difficult to determine who the attacker is. Indeed, it's easy to spoof the origins of an attack. In other words, you may think you know that it's this has got to be about coffee. Should I stop and read it?
Nope.
There will be no coffee breaks throughout the conference because of funding cutbacks. Okay. With regard to the identification of the attacker, the question is, what's my standard? What standard do I apply when I've been the victim in determining whether or not I can strike back now? Well, we certainly don't use a preponderance of the evidence or a beyond the reasonable doubt standard. I think a reasonable standard is one articulated by the United States in 2001 when it made notification to the Security Council that it was responding in self-defense to the attacks of 9/11. And in the letter that was transmitted to the Security Council, the standard that was enunciated was clear and compelling. We have clear and compelling evidence that we've been the victim of attack by al-Qaeda and the Taliban. This was not just an American thing, because when the NATO Secretary General announced that Article 5 of the North Atlantic Treaty was in play, again, Lord Robinson said, we have clear and compelling evidence that acts occurred which would bring Article 5 of the North Atlantic Treaty. So to me, clear and compelling is a reasonable standard for identification. You don't have to be right, but you have to have had clear and compelling evidence that the attacker was who you believed the attacker was at the time. In other words, you can't act precipitously, but at the same time, you don't have to sit back and suffer attacks because you don't have absolutely dispositive evidence of who the attacker is. Collective self-defense, just very briefly, there is, of course, the right to collective self-defense. It's critically important in the context of cyber because the country that is the victim of the attack may not have the capacity to respond effectively to the cyber attack. Georgia, which has some problems, clearly could not respond to the attacks being conducted against it. And as you'll see, they turned to other countries to help them. That was also the case in Estonia. If Canada is attacked, General, we'll be there for you, okay? Yes. Finally, two other topics, and then I'll close. First, state sponsorship of attacks by non-state actors. In other words, state sponsorship of attacks that are cyber attacks that are conducted by hacktivist groups of hackers. Derek is going to speak at length about state responsibility, so I won't address state responsibility. The only thing I'm interested in is when is an armed attack attributable to another state? Are you going to talk about that, Derek?
I am, but please.
Just in case we come to different conclusions, it'll be entertaining, or? Yeah, okay. Very briefly, with regard to attribution, the Nicaragua case set forth the standard. It said that a state that sends armed bands, groups of irregulars, or mercenaries to another state to conduct attacks on its behalf, you can attribute those guerrilla attacks to the state which sent them. This was the accepted standard until 9/11. In 9/11, clearly, the Taliban government had not sent al-Qaeda against the United States. In fact, if you look carefully at the relationship between al-Qaeda and the Taliban, you may make the argument that the Taliban was actually more reliant on al-Qaeda in its fight against the Northern Alliance than the other way around. Yet, nevertheless, when the United States and its coalition partners launched attacks against not only al-Qaeda, but against the Taliban, no one complained. No one complained. On the contrary, states lined up and said, hey, can we come help you in collective defense? And therefore, this brings into question the extent to which state involvement in an activity will result in being able to treat the state's involvement as an armed attack by the state itself. And this is extraordinarily relevant in the cyber context because the state may host the server, for example, that is used by the hacktivist to conduct the attack. The state may develop the software that will be used by the non-state actor to conduct the attack. So I don't know what the standard is. Derek will tell us in 35 minutes. But it seems to me that the Nicaragua standard is gone, and it has been reduced substantially. I just don't know how far it's gone. And finally, we have the issue of armed attacks by non-state actors. It's relatively, it's a major issue because we've been finding terrorist groups that have hacker tools on their computers when we seize their computers, so it's going to happen. Can a non-state group conduct an armed attack? In my mind, that was answered through state practice in the aftermath of 9/11 when everyone, including the Security Council, treated the attacks by al-Qaeda as an armed attack. So this created, I believe, state practice and state interpretation of Article 51, such as there need be no state involvement before the right to respond defensively under Article 51 to non-state actors arises. Now, there have been two ICJ opinions that have brought this into question. We have Ian Scooby, who's a world expert on this area of law. You catch him at break, he'll explain it. But they have both, the Wall opinion, advisory opinion, and the Congo judgment have both brought into question whether or not operations by non-state actors are armed attacks allowing you to respond defensively. I'll make a long story short. The ICJ was wrong. There are dissenting opinions that correctly point out the flaws in the logic of the opinions, and states appear to have ignored these two ridiculous opinions, which begs the question of you have non-state actors in another state. If you have non-state actors, a hacktivist group in State B, which is conducting attacks against State A, when can State A operate in State B to shut down the cyber operations? Excuse me, it's an interesting question that has a lot to do with UAVs and crossing into Pakistan. It's equally relevant in the cyber context. In my view, the law is relatively simple. You have to balance the right of sovereignty on the part of State B against the right of self-defense in State A. In international law, when you balance rights, you don't say one wins over the other. You say, let's seek the reasonable accommodation of these two conflicting rights. What's a reasonable accommodation of these two conflicting rights? In my mind, the reasonable accommodation goes like this. State B has an obligation under international law to ensure its territory is not used to the detriment of its neighbors. It must comply with that obligation. State A, before it takes action, must ask State B, listen, man, they're conducting cyber attacks against us from your territory. Do something. If State B fails to act, either because it cannot, maybe it doesn't have the cyber resources to do so, it's very complicated stuff, or because it chooses not to, because they don't like you and they're in bed with the hacktivist group, then you have the limited right to conduct operations into State B to shut down the attacks that are being conducted against you or which are imminent. And that's your only right. You can't go beyond that, but you certainly have that right, and when you've achieved that purpose, it's end X, you must withdraw. Either withdraw your forces or shut down your cyber operations into State B, because there's no longer a threat and your right to self-defense has faded away. I think that's all I have. Yeah.
Okay, thanks to Mike for actually pulling that very interesting and usually opinionated brief out of his hat on about 45 minutes notice. So now you've earned your coffee break, and we'll take 15 minutes, please, and then be back here.
10:05.
10:05.